Okay, good evening, everybody. A very warm welcome to this third and final panel on refugee protection and the case of AAA and others, titled Enabling Refoulement, the UK-Rwanda Agreement and Safety of Rwanda Bill. So tonight's event is hosted by Border Criminologies and the Refugee Studies Centre at Oxford and the Dickson Poon School of Law. My name's Alpa Parmar and I'm at the University of Cambridge and I'm an Associate Director of Border Criminologies. So it's my great pleasure to be chairing the seminar this evening. We have an excellent and accomplished lineup of speakers on the panel, including the co-conveners of this series, Dr. Nicola Parmar and Dr. Catherine Briddick. I'll invite the speakers to introduce themselves in a moment. However, by way of background to the issues, so most of you will know that the use of safe third country practices to send asylum seekers elsewhere is well established in Europe and beyond. Now, in 2022, the UK entered into a memorandum of understanding with Rwanda, the only African state to have previously engaged in these practices. Following this, in November 2023, the Supreme Court in AAA and others held that the Secretary of State's policy to remove protection seekers to Rwanda was unlawful because of the risk that asylum claims would not be determined properly and the possibility of ill treatment if returned to their country of origin. The UK government's response to the judgment was to draw up a new treaty to replace the memorandum and to bring in new legislation proclaiming Rwanda to be a safe third country. This bill is currently before Parliament. So in today's seminar, the speakers will place the bill in its broader context of post-Brexit politics and the racialisation of refugee protection, and we'll consider the bill in light of the Supreme Court's ruling in AAA. Each panellist will speak for around 8 minutes, followed by 20 minutes or so for questions at the end. If you could post your questions in the Q&A, I'd be really grateful. So over to the panel to introduce yourselves, please, and we'll start with Jonathan, if I may.
I'm Jonathan Portis. I'm Professor of Economics and Public Policy at King's College London.
Thank you. Catherine?
Good evening, everyone. I'm Catherine Briddick. I'm an Associate Professor of International Human Rights and Refugee Law here at the Refugee Studies Centre.
Thank you. Nicola?
Good evening, everyone. I'm Dr. Nicola Parmar. I'm a reader in criminal law here at the Dickson Poon School of Law, King's College London.
Zoe?
Thank you, Alpa. I'm Zoe Bantleman. I'm a barrister and I'm the Legal Director of the Immigration Law Practitioners Association, ILPA.
Thank you. And Sheila?
Hi, everybody. I'm Sheila Reynolds. I'm the Head of Asylum Advocacy at Freedom from Torture.
Thank you very much. So over to you, Jonathan, to kick us off.
So I guess my job here is to provide some of the sort of historic and political context. Unlike the panel and probably most of the participants, I don't have a legal background. I think I would go back to when I first started working on migration issues, which was when I was a civil servant in the Cabinet Office in the late 1990s, early 2000s, when I wrote a paper which subsequently became quite well known or indeed notorious, setting out a framework for the UK's approach to immigration more generally in the context of globalization and the economic imperative to liberalize migration. Something which, of course, was to some extent at least translated into policy, the view that there were good economic reasons why the UK should adopt a more liberal approach. But at the same time as we were pursuing that agenda on the economic front, there was also a growth in the number of asylum seekers. And this was, I think, when refugee and asylum first became a significant issue in modern UK politics. And so at the same time as the Blair-Brown government was, from an economic perspective, pursuing broadly liberal policies, there was also something of a backlash, both in the media and politically, and also to some extent within government, at the rise in the number of asylum seekers and the perceived difficulty in dealing with the asylum, quote, problem, unquote, problem. And so shortly after my work concluded, and this resurfaced in the papers just a couple of weeks ago, Blair commissioned a study that, among other things, looked at the possibility of offshoring asylum processing. Not the, as also was pointed out, the proposal then was still very much that asylum would be considered within the UK legal framework, and people who were successful would have the right to asylum here. But this was in a context when asylum grants were much, most people who applied for asylum in the UK at this point were denied asylum. So the problem then was not what is perceived by government as being the problem now, which is that people mostly get asylum, which was that those who were denied asylum often could not be removed for one reason or another. And it was perceived that if you offshored processing so that people who were denied asylum wouldn't be able to come here, that would be a deterrent effect. That would be seen as a deterrent from coming to the UK in the first place. So this history of offshoring asylum processing as a way somehow of deterring people from coming here in the first place, and hence solving the government's perceived political problems, has a long history, not in the form which it, of the Rwanda bill, but in one way or another, this idea that this would be a silver bullet for the perceived, for the political difficulties of governments in dealing with asylum seekers, does go back quite a long time in UK politics. Now, fast forward 15 or 20 years, and we can see that once again, you have a government which is trying to, on the one hand, adopt a relatively liberal position on economic migration. And of course, migration levels overall are now higher than they've ever been in recorded UK history. Legal migration through the work, study, and other routes is now higher than it's ever been. And so you have this paradox of a government trying to project the image, the view that it's in control of the system, and in order to do that, it has to project an image that it's in control of the asylum system, the refugee and asylum system, even though almost by definition, there are limits to the extent to which governments can indeed control that. So I think the sort of political context here is governments' attempts to square the circle here, or the trilemma, being that, and it's one that Hein de Haas identified in his recent book, which many of you, I suspect, will have seen or at least read the reviews of, trying to square this circle of the desire of the public to see the migration system as something that its government has control over, even though that control is very difficult across the whole spectrum, but particularly when it comes to refugees and asylum seekers. This desire for control at the same time as the economic imperative of having a relatively liberal system for work and for study, something that I think is particularly acute in the case of the UK, because the UK, given its the nature of the UK economy, relatively open, relatively dependent on trade, relatively dependent in particular on trade in services, all of which mean that having an economy that's relatively open to legal migration is that is part of our economic model. So this conflict between the desire for control on the one hand, that comes from the public and hence the politicians, the desire for and the economic imperatives on the other, and then a legal system, which in the UK, of course, is relatively friendly still to concepts of individual rights and human rights, particularly for people who've arrived here and are in the system in one form or another because they managed to make a claim for asylum. So reconciling that trilemma remains very difficult, and governments struggle with it. Not sure whether you could describe the Blair-Brown government as being particularly successful, but it was certainly rather more successful in doing that than the current government, which seems to have managed to alienate pretty much the entire spectrum here. So I'll finish there by saying that, while I have little or no sympathy for this government and its approach to the trilemma, we shouldn't delude ourselves that even under a more rational and more competent, as well as a more humane government, that these issues will go away. So as well as doubtless condemning many aspects of the government policy, which I suspect all of our speakers will do, we should also try and think constructively about how a future more rational and more humane government might approach these, because they're not easy issues to solve. I'll stop there. Thank you.
Thanks, Jonathan. Over to you, Catherine.
Thank you very much indeed. Nicola and I are going to address the treaty directly in two different ways. I'm going to do so by talking about norm conflict. So writing in 1937, someone called Alfred von Verdos asserted that states' right to make treaties was much more limited than was generally assumed, either in international law or in states' diplomatic practice. He explained that the coming into existence of any treaty was dependent on norms or principles which existed independently of the will of the contracting parties. International law, he said, would not admit treaties between subjects which were obviously in contradiction to the ethics of a certain community. He described treaties which contradicted these ethics as being forbidden. Now, Verdos made a significant contribution to the development of international law. Notably, he was a judge at the European Court of Human Rights, and he went on to join the International Law Commission. And there he gave expression to his legal thinking in something called the Vienna Convention on the Law of Treaties. Now, international law would be nothing if we didn't have a treaty on treaties, and this is it. It tells us what makes a treaty come into effect. It tells us how parties to a treaty are to conduct themselves in the event of dispute, and what mechanisms are available to parties and the international community as a whole in the event of a norm conflict. So Article 53 of the VCLT states that a treaty is void if, at the time of its conclusion, it conflicts with a peremptory norm of international law. Peremptory norms are use cogens norms are norms from which no derogation are permitted. What we don't know, however, is what the invalidating effect of use cogens is on a deviating treaty. It's not something that's been put to a test before international courts or tribunals, but it's one that is being put to the test by the UK agreement with Rwanda. And the reason for that is that there is a general consensus in international law that sending someone to a situation where their life or freedom would be at risk, the prohibition on refoulement, has attained the status of a use cogens norm. There are a number of ways in which I could argue this, but I just want to quote one person, Professor Deir Taladi. He's now a judge-elect of the International Court of Justice, but he served the International Law Commission as its special rapporteur on use cogens norms. And having conducted a vast survey of state practice and relevant rules, he concluded that the principle of non-refoulement is one in international law whose candidacy for peremptory status has ample support. So what we have with the UK-Rwanda agreement is a conflict of norms, the prohibition of refoulement on the one hand, and the VCLT's very clear statement that any treaty which conflicts with the norm is entirely void, so it doesn't exist. The question then is how a norm conflict can arise in this case. And I think there are two levels on which we can conduct this analysis. The first is a structural level, looking at the agreement itself and its accompanying domestic legislation, which Zoe will address in a moment. Here we have a conflict because the treaty itself is designed to circumvent the factual findings of the UK Supreme Court. So I know that many of you attending this evening will have watched or attended our previous seminars on the AAA judgment. And you'll recall from those that the UK Supreme Court, in a unanimous decision, applied very clear and uncontested legal principles to the undisputed evidence of UNHCR and made a series of findings about refugee determination processes in Rwanda. And the Supreme Court, having gone through this process, affirmed that safety had to be assessed in individual cases, by courts, and empirically. So on the basis of the factual situation that a particular protection seeker would face. Now, the UK-Rwanda agreement imposes new obligations and it reiterates old ones, but it does nothing to change the court's assessment of the factual situation in Rwanda and Rwanda's capacity to recognize refugees or others in need of protection. What is changed by the agreement is the creation of a mechanism which enables individuals to be removed from the UK to Rwanda, from effectively preventing their challenging those decisions, but also preventing them from challenging their deportation from Rwanda. So there's a structural level at which this norm conflict may occur. The second level is through the presence or absence of particular elements of the treaty. And I'm not going to go through the whole thing, but I just want to highlight some elements of the treaty which are problematic. The first is that the agreement itself does not contain a general clause that requires the UK and Rwanda to act in compliance with all elements of the prohibition on refoulement. General references are made to international human rights law and the Refugee Convention, but there's no what's called a saving clause, a clause that requires these legal instruments to be treated as paramount for the purposes of this agreement. The agreement also leaves undetermined the basis for deciding claims for complementary or subsidiary protection. And indeed, Article 10.2 of the treaty refers to humanitarian protection needs, but doesn't match on to the UK's broader obligations under things like CEDAW, the Women's Convention, or the ECHR. At the same time, the agreement envisages the return of children or the deportation of children to Rwanda and the removal of people who have been recognized as victims of trafficking, but doesn't discuss the legal rules or regimes in addition to refugee protection that protects this group of people. So, for example, the UK's obligations under the Council of Europe's Trafficking Convention, or most notably the UN Convention on the Rights of the Child. So we have norm conflict potentially being here at two levels: the existence of the treaty and bill itself as an attempt to circumvent the reasoning of the Supreme Court, and particular elements of the treaty which don't match the UK's international obligations. Now, as I've said, the consequences of a treaty which conflicts with the jus cogens norm is that it's void in its entirety. But for this to actually be found to have occurred, certain processes have to be followed. And these are set out in the VCLT, and they include things like litigation before the ICJ. So I want to end on just two reflections about these processes, because the first one is to think about who in any such litigation would reflect the interests of refugees, because it's not going to be either the UK or necessarily Rwanda. And it's unlikely to be the state from which a person fled. Now, jus cogens norms generate obligations for the international community as a whole, but that's no good if there's no state or no group of states that's willing to act on behalf of refugees. The second thing I wanted to talk about was democratic processes domestically. Some of the arguments that I have made here, I set out in more detail in some evidence I wrote with Professor Catherine Costello for the International Agreements Committee of the House of Lords. And 2 days ago, the House of Lords voted against ratification of this treaty on the basis of the report of the International Agreements Committee. Now, that gives us some indication that both democratic processes and legal adjudication are going to be necessary if measures like this bill and this treaty are to be defeated and refugees' rights protected both in the UK and internationally. Thank you very much.
Thanks, Catherine. And over to you, Nicola.
Thank you, Alpa. So I'm coming to this as an international lawyer who's worked in and on Rwanda since 2006. And so in my contribution, I want to focus on what the UK-Rwanda Treaty means for legal change in Rwanda. With, as Catherine said, the Lords voting on Monday in line with the recommendations of the International Agreements Committee, that the treaty should not be ratified, and I'll quote here, until Parliament is satisfied that the protections it's provided will be fully implemented. And so as a result, there's a huge push for fast legal change in Rwanda. And so what I want to suggest tonight is that it's very unlikely that this proposed legal change will enhance judicial independence in Rwanda, and it's more likely that it will narrow existing access to protection for refugees coming specifically from neighboring countries. And so to do this, I want to draw attention to two specific areas. First, I want to suggest that the MEDP, the Migration Economic and Development Partnership, which is now being realized through the treaty, has already pushed changes in Rwanda's approach to determining refugee status away from prima facie recognition and towards individual assessment. And early figures suggest that this is leaving people seeking refuge in Rwanda from the Democratic Republic of Congo and Burundi in particular more vulnerable. And then second, I want to suggest that the enhanced role for foreign judges in Rwandan courts, which is proposed through the treaty, taking the form of an appeal body, is not an entirely new idea. So since 2012, this has been possible in Rwanda in certain criminal cases. Yet, despite this law being on the books for nearly 12 years now, a foreign judge is yet to be involved in a trial in Rwanda. And so overall, my concern here is that the shifting of judicial resources into a new bespoke individual refugee determination process and away from the general administration of justice is not good for legal provision in Rwanda or in the UK. And I'm deeply concerned that it's not in the best interests of most people who arrive in Rwanda already seeking refuge. So the Supreme Court notes in AAA Syria and others that, and again I quote, Rwanda maintains an open door policy for refugees fleeing conflict in neighboring countries, particularly the Democratic Republic of Congo and the Republic of Burundi. Refugees from these countries have been permitted to remain in Rwanda without going through any formal asylum determination process. What I want to show is that since the UK first initiated negotiations regarding a migration agreement with Rwanda in 2020, this open door policy is being undermined. In figures provided by the Rwandan government as part of the information for members of parliament who are currently in the debating of the Safety of Rwanda bill, the following pattern emerges. From 2019 to 2023, the figures of individual refugee determinations rose from 17 to 164. Now, these figures, of course, are still very low in the context of over 130,000 refugees currently living in Rwanda. But the trend is clear and has been directly as a result of efforts to secure the migration arrangement. What is clear is that this has been at a severe disadvantage for refugees coming from neighboring countries, particularly Burundi and the DRC, people who, prior to the UK's idea of exporting its obligations under the Refugee Convention, were receiving prima facie refugee recognition. So if we just look at 2023, 78% of all individual asylum claims were rejected. And the vast majority of these rejected applicants, 83% of them, were coming from the DRC or Burundi. So in a bid to secure the MEDP, the legal change in Rwanda already does not appear to be leading to a greater knowledge of obligations under the Refugee Convention, but rather to a notable narrowing of who is going to receive the benefits that come with refugee recognition. Now, this comes at a very delicate time in interstate relations in the Great Lakes region. On the 12th of January, it was reported that the Rwanda-Burundian border was shut altogether based on allegations made by Burundi that Rwanda is supporting the Red Tabara rebel group operating near Burundi's western border with the DRC. while in the DRC, President Felix Tshisekedi started his second term of office this week, and he stated during the final days of his presidential campaign that he would declare war on Rwanda and march on Kigali. On Sunday afternoon, according to South African news sources, Burundian President Evariste Ndiyishima stated in a press conference that he would support liberating Rwanda. My point here is that border tensions between these three countries are extremely high, and the enhancement of legal mechanisms of social exclusion of Burundian and DRC nationals within Rwanda is not something that should be undertaken lightly, and certainly not done in the name of enhancing Rwandan legal capacity to realize its obligations under the Refugee Convention. And so I move to my second point on judicial independence. In AAA and others, the Supreme Court stated that in determining whether a real risk of refoulement arises, the main issue is whether or not the individual will have access to an adequate asylum procedure in the receiving third country. At the heart of the assessment of the adequacy of Rwanda's individual asylum process was a concern regarding the independence of the Rwandan High Court and Rwandan lawyers, judges, and government officials' general expertise and knowledge regarding the interpretation of the Refugee Convention. The UK-Rwanda Asylum Partnership Treaty tries directly to address these concerns. Under Section 4, the treaty describes a new appeal body which for the first 5 years, although extendable beyond this, shall have 2 co-presidents, 1 Rwandan and 1 being a Commonwealth national with asylum or humanitarian protection expertise. Now, these presidents will appoint an appeal body of judges from a mix of nationalities to determine all appeals following individual refugee determination processes, which is really a push through a treaty to try to make a statement about and reinforce the independence of the Rwandan judiciary. Yet, the proposal to have foreign judges sit on cases before Rwandan courts is not new. As I stated at the start, since 2012, in an effort to secure the transfer of genocide suspects from third states back to Rwanda, the president of the Supreme Court of Rwanda has been able to appoint foreign judges to sit with Rwandan judges in cases of international cross-border crimes committed on Rwandan territory or abroad. The key, however, is that despite this legislation being in place now for nearly 12 years, there's never been a foreign judge sitting in any of the criminal cases that have arisen from extraditions and deportations to Rwanda. Article 13 of this organic law determining the organization, functioning, and jurisdiction of the Supreme Court has had no real practical effect. Up to now, it's been a legislative move that the Rwandan government has drawn on to make a public statement that they have nothing to hide and that their overall justice system is independent, robust, and open to international scrutiny. In addition, this measure, although in place at the time, did not influence the UK Divisional Court's decision to refuse to extradite 5 genocide suspects to Rwanda in 2017. This decision in the case of Nteriziyayo was relied on heavily in the AA decision by the UK Supreme Court in its own findings that the existing appeals process in Rwanda prior to the treaty changes was inadequate. So while the protections provided by the treaty are likely to be reflected in Rwandan law relatively quickly through the passing of an organic law, it's very unlikely to be enacted in practice very easily. And I want to suggest, more importantly, I'm deeply concerned that these changes will undermine the protections offered to the majority of people coming to Rwanda as refugees fleeing persecution from neighboring countries.
Thank you, Nicola. Over to you, Zoe.
Thank you, Alpa. This evening, I would like to discuss what the Safety of Rwanda Asylum and Immigration Bill does by focusing on 3 key aspects of the bill. First and foremost, it legislates the fiction that Rwanda is a safe country. Second, it ties the hands of decision makers and thereby places the UK at significant risk of further breaching its international legal obligations, building on the breaches already identified in immigration and asylum legislation that's passed in the last 2 years. Third, the bill fundamentally undermines the universality of human rights. And I want to address each of these in turn. So turning to the first point, despite the changing laws and legal procedures in Rwanda, the bill ossifies at this point in time a conclusive legal fiction. And I would go so far as to say, based on the objective evidence referenced in the International Agreements Committee's report, which we submitted and Catherine submitted, that it's not just a fiction, it's a falsehood that Rwanda is a safe country. Now, what is a safe country for the purposes of this bill? It's a country to which persons other than Rwandan nationals may be removed from the United Kingdom in compliance with all of the UK's obligations under international law that are relevant to the treatment in Rwanda of persons who are removed to Rwanda. And that's removal under immigration acts, starting from the Immigration Act 1971, all the way to the piece of legislation that passed last year, the Illegal Migration Act 2023. And importantly, to go back to the fundamental point of this Rwanda scheme, and to borrow the language from Lord Kerr earlier this week, this is offloading. It's not offshore processing. So plainly, a fiction does not, in fact, make Rwanda safe. Nevertheless, under this bill, the fiction applies notwithstanding the Human Rights Act, notwithstanding any interpretation of international law, and notwithstanding domestic law, including the common law. And it's crucial to note that in this bill, which is drafted to come into force on the date that the Rwanda Treaty enters into force and is ratified, it's the on button, so to speak, for this fiction. And the bill contains no off button. A further piece of primary legislation would need to be passed to turn it off if a reasonable government in the future were to accept that the situation was such that Rwanda was not, in fact, generally safe. And this is particularly important because Section 2 of the Illegal Migration Act 2023, which has yet to be commenced, contains the underlying statutory obligation on the Home Secretary to make arrangements for the removal of people who arrive in the UK irregularly. They can be removed to third countries with which they have no connection, including Rwanda. Once that's turned on in the Illegal Migration Act 2023, and it would, unless the date is altered, apply to people who arrived since the 20th of July last year, and that's already a huge population of tens of thousands of people currently in limbo. There would be a duty to make arrangements for their removal, and in doing so, the Home Office and also our courts and tribunals would be required to treat Rwanda as conclusively safe. Now, given that the situation in Rwanda on the ground is clearly still evolving, not only in terms of law and procedure, but also, as Nicola has said, in terms of its tensions with its neighbouring states, it should be for our independent judiciary to conduct an up-to-date, fact-sensitive assessment. That's the proper function of our courts. They're an appropriate check and balance, and that has to be recognised by upholding the principle of the separation of powers, and in our constitution, also respect for comity. The second point that I want to turn to is the issue that the bill ties the hands of the Home Secretary, the Home Office, and also our domestic courts and tribunals. It places a mandatory statutory obligation on all of them to conclusively depart from the recent fact-finding of our Supreme Court. None of them can ever question whether Rwanda is in general a safe country. Our courts and tribunals thus have their purview, the extent to which they can review the legality of the UK's conduct, ensure that the UK does act lawfully, and prevent it from acting unlawfully, gravely limited. Even our highest court, the Supreme Court, is barred from ever revisiting the question of whether individuals sent to Rwanda are at real risk of ill treatment, of refoulement, including on the basis of any new evidence that they would still fail to have their asylum claims properly and fairly considered and decided. Indeed, the bill actually goes further than that. It would appear that the intention of the draftsman is that no question regarding the UK's compliance with international law through removal to Rwanda on the basis that Rwanda is not a safe country in general, whatever general may mean, may be considered. All that is intended to be left are crumbs. The Home Office and the Domestic Court or Tribunal can consider whether Rwanda is, and I quote from the bill, a safe country for the person in question based on compelling evidence relating specifically to the person's particular individual circumstances, close quote. If the individual has no compelling evidence, which itself is a term that remains undefined in statute, or if their claim would have been made on the basis of Rwanda's general lack of safety, the purview of our courts is limited. And this is, of course, deeply problematic. Under Article 3 of the European Convention on Human Rights, the UK is required to conduct a thorough examination of the question of whether the receiving third country's asylum procedure affords sufficient guarantees to avoid an asylum seeker being removed directly or indirectly to his country of origin without a proper evaluation of the risks he faces from the standpoint of Article 3 of the Convention. And that's clear. I'm quoting that from the case of Ilyas and Ahmed in Hungary. And it must be an up-to-date assessment of the facts and all generally available information at the time of the expulsion. If there are insufficient guarantees and safeguards, Article 3 implies the duty that the individual will not be removed to Rwanda. What the bill does is it inhibits a proper evaluation of the risk from the standpoint of Article 3 of the European Convention on Human Rights. It prohibits not only a thorough examination, but rather any examination of whether Rwanda's new asylum procedure, including its forthcoming new asylum law and untested first instance body and appeal body, afford sufficient guarantees against refoulement. Even more crucially, the ability of our courts and tribunals to prevent illegality is restricted or removed. The bill contains no domestic remedy with automatic suspensive effect, leaving Section 4 of the Human Rights Act, which is the ability of a court to grant a declaration of incompatibility, is wholly insufficient. The ability to grant interim remedies for individuals not removed under the Illegal Migration Act is limited under the bill to satisfaction that before the review or appeal is determined, a person would face a real, imminent and foreseeable risk of irreversible harm if removed to the Republic of Rwanda. So a limitation of what the courts can currently do in relation to granting interim remedies. For those to be removed under the Illegal Migration Act, and this is really critical because it's the act that one would imagine the government would wish to use and turn on, the full ouster in Section 4 of that act applies. So courts and tribunals can grant no interim remedy that prevents or delays removals. And this ouster is so fundamentally contrary to the most orthodox interpretation of the rule of law. It was Albert van Dicey who said, when we speak of the rule of law as a characteristic of our country, we mean not only that no man is above the law, but that here every man, whatever be his rank or condition, is subject to the ordinary law of the realm and amenable to the jurisdiction of the ordinary tribunals. And what this bill does is remove them from that very jurisdiction. So given the lack of domestic interim remedies, individuals have no choice but to go to Strasbourg. Then what does the bill do? It also removes the ability of our courts and tribunals to have regard to Rule 39 interim measures indicated by the European Court of Human Rights. So it places at risk violation of the right to individual petition under Article 34 of the European Convention on Human Rights, were a minister to decide to fail to comply with such an interim measure. Clearly, this will be a matter of concern for the Committee of Ministers of the Council of Europe. But importantly, under the bill, the UK would still remain bound by a final binding decision from the European Court of Human Rights. And Article 46 of the European Convention on Human Rights applies. And if the UK fails to abide by that final judgment, again, it will have to answer to the Committee of Ministers, but it will also be responsible for any breaches, and it will have to face a damage to its human rights record and its international reputation. And of course, the European Convention on Human Rights is critical to the Good Friday Agreement and also to our agreements with the European Union and the Windsor Framework. Third, and my final point, is that the bill fundamentally undermines the universality of human rights. Again, as with the Illegal Migration Act, it's accompanied on its very face by a Section 19(1)(b) statement that the minister cannot say that it's compatible with convention rights. And it carves out anyone who may be removed to Rwanda as somehow less deserving of the full protections conferred by Sections 2, 3, and 6 to 9 of the Human Rights Act 1998. Let alone the international law, which courts and tribunals are forced to act notwithstanding their interpretation of our obligations under those laws. So the conclusive legal fiction, coupled with the prohibition on domestic interim remedies, the disapplication of key provisions of the Human Rights Act 1998, and the power to ignore interim measures of the European Court of Human Rights, it's a recipe for putting individuals at risk of breaches of their human rights with no recourse to an effective domestic remedy, and it's going to place the UK on a direct collision course with domestic courts, the European Court of Human Rights, and the Council of Europe.
Thank you very much, Zoe. And our final speaker is Sile.
Thanks, Alpa. For those who don't know, Freedom from Torture is a human rights charity, and it's the largest torture rehabilitation service in Europe. We provide specialist therapeutic support across the UK to people who've survived torture, most of whom are asylum seekers and refugees. We also are more directly involved in the asylum process. So we provide independent and forensic assessment and documentation of torture, usually to inform an assessment of a survivor's protection claim. And this means that we have a really, really good understanding of just how difficult it already is for refugees in the UK to have their status recognised and to secure protection. Most of you probably know this already. Freedom from Torture is very committed to fighting the Rwanda scheme, because we know that the public don't want the UK to become the kind of country that abdicates or indeed offloads its responsibility for providing protection to refugees. And the public polling upholds this. But we're also doing it for reasons that directly relate to our client base. It was clear from the very outset of this scheme that survivors of torture, many of our clients, arrive through dangerous routes and could well fall within the general eligibility criteria for the Rwanda scheme. So the first question that I was asked to talk through tonight was why refugees, why survivors of torture amongst them, come to the UK irregularly. In answer to that question, I would direct you to Freedom from Torture's 2022 research report called Fleeing a Burning House, which explains why survivors take dangerous journeys to seek protection in the UK. And in brief, they have very little choice in the matter. The first myth to bust, I guess, is the idea of generous and accessible pre-authorised routes to seek sanctuary in the UK. As you all will know, it is impossible to secure a visa for the purpose of seeking asylum in the UK, and yet the vast majority of those who are granting asylum in this country are from countries where whose nationals must hold entry clearance in order to enter. So that's a pretty significant obstacle. Many of the schemes that do exist offering some form of pre-authorised access to the UK via usually resettlement have in fact closed or significantly reduced, and most of the remaining schemes are country specific. Even despite the much trumpeted safe routes from Afghanistan, we continue to see Afghans as one of the top nationalities represented in the small boats crossing the Channel. So the second myth is the extent to which UK immigration policy actually informs refugees' decision-making. And those who've watched closely the passage of the Illegal Migration Act will remember that the impact assessment of the bill, as it was, declared that the academic consensus is that there is little to no evidence suggesting changes in a destination country's policies will have an impact on deterring people from travelling without valid permission, whether in search of refuge or for other reasons. And those are the government's own words. So what is true is that survivors don't take this decision lightly. Many of our clients have undergone traumatic journeys to reach safety here, some of which have spanned years. And many don't choose this route as it's chosen for them by family members or by smugglers. For those who do choose it, why? Why do they choose to take that risk? Well, firstly, many reported that they don't feel safe en route. So not only have they fled torture in their country of origin, but many of our clients report experiencing violence, exploitation, detention, racism, destitution, and indeed torture on their journey to the UK, and particularly those who have passed through Libya. Secondly, they come seeking reconnection with family and community, as any of us would do. Thirdly, they come because they are familiar with the English language and the UK's culture and institutions. And finally, they believe that the UK is a place where human rights are respected. And it's this last point that our clients go back to when talking to our clinicians about Rwanda. They tell our clinicians every single day in therapy sessions with them how terrified they are of being sent to a country with which they have no connection and from which they may well be sent back, or at least they believe they may well be sent back into the hands of their torturers. And they can't believe that the UK would play so fast and loose with commitments that we've made to uphold the international legal framework of human rights and refugee protection. So as an organisation, we decided to get involved in the Rwanda Judicial Review because we are experts in the identification of torture and trauma and in the impact of accelerated procedures on vulnerable individuals. We submitted witness evidence to the High Court. We then intervened in the asylum aid claim in the Court of Appeal, which concerned the lawfulness of the process by which individuals' suitability for relocation to Rwanda would be assessed. The crux of our argument was that the way in which the Rwanda policy was being implemented would lead to a systemic failure to identify survivors of torture. Now, one of the really important ways to identify indicators of torture is through forensic assessment by a medical expert and the production of a medico-legal report, an MLR, which is one of the things that Freedom from Torture does. We argued that the accelerated process under the Rwanda scheme would effectively make it impossible to obtain an MLR and therefore to determine whether someone was unsuitable for removal to Rwanda due to a risk of serious harm. Now, while the procedural fairness grounds in the Rwanda JR didn't end up succeeding, the claimants did secure some really helpful statements regarding what was required of the process in order to make it lawful. And what we're now seeing in the debate around the safety of Rwanda bill is that this core element of the procedure, the legal remedy, or what remains of it, has become a real battleground. Now, we would argue, as Zoe has already explained very well, that the remedy within the bill that allows for the consideration of a risk of harm for a very narrow category of individuals on production of compelling evidence does not make the bill compliant with international law and will by no means protect our clients from removal to Rwanda and everything that entails. Now, we know that the Rwanda scheme won't work. I think probably everybody knows that now. Refugees will keep moving to find safety, regardless of the hardship that they might face. So the question really remains, how should the government respond to those who continue to make such journeys? Now, Freedom from Torture believes that the government should first of all, focus on the people who are in the boats, rather than the anonymous number of arrivals and the patently unachievable goal of stopping the boats. A focus on the people would necessitate an understanding of the drivers that keep pushing them to take the journeys in the face of unrelenting hostility and danger. Now, secondly, the government should recommit to the vision and values represented by our involvement in the new order created in the wake of World War II, a vision of a world where survivors and other refugees would not be turned away. Now, that means in practice, overturning legislation that deliberately seeks to punish refugees for their method of entry by denying them access to the UK asylum system. And it means an end to the Rwanda scheme and no other similar schemes being introduced. We think that the government should allow access to the UK asylum procedure for all those who arrive seeking sanctuary on the territory of the UK. Now, does that mean providing protection to all those who arrive? No, of course it doesn't. Some will not qualify on refugee protection grounds, but that is a decision to make following a fair hearing and careful consideration within an efficient and humane asylum system. It's not a decision to make at the border. Now, do we currently have a fair, efficient and humane asylum system? Absolutely not. Decades of neglect, mismanagement and under-resourcing have left us with a system that is dysfunctional, opaque, crippled by political interference and unable to sustain whatever small shreds of positive reform are undertaken. Now, a good asylum system would look a lot like that described in our Refugee Rights Manifesto, which Freedom from Torture has drafted in partnership with survivors of torture. And it would have three key elements. Firstly, it would be accessible and welcoming. It would be flexible enough to respond to fluctuating numbers arriving by a variety of means, always able to treat with dignity those who arrive and prioritizing identification of health needs and vulnerability. Secondly, it would be a system that guarantees access to justice by providing legal aid funded legal advice throughout the process, ensures access to expert evidence when needed, and preserves legal remedies to correct flawed decisions. It would expedite clearly well-founded claims and resource casework units to make all decisions efficiently. There would be no immigration detention, no barges, no barracks, just safe community-based accommodation for all. And thirdly, it would recognise that refugees are potential future citizens by granting indefinite leave from the outset with a quick and affordable route to citizenship and generous family reunion rights. And it would facilitate education, English language training, and allow the right to work. Now, I'm well aware that all of these proposals sound unrealistic and idealistic right now, but it's worth remembering that barges and mass detention, expulsion and destitution are not the inevitable result of the global shifts in refugee displacement. They are a political choice. And of course, none of these proposals are now possible without a mandate for progressive reform, which I fear will remain out of reach while those in power fixate on the objective of stopping the boats. None of us wants people, anyone, refugees or others, to keep dying in the Channel, or indeed in the Mediterranean, or while crossing land borders into Europe. But while the drivers that push refugees to move across borders continue to exist, there will always be a market for the smugglers and the traffickers. 20 years ago, refugees died travelling under trains or in sealed refrigerated lorries. This isn't a new phenomenon. And as Jonathan was explaining, neither is the favoured solution of deterrence. It is possible to reduce the reliance on such routes, and it is possible to make those routes marginally less deadly. The government could expand pre-authorised routes by setting a far more generous resettlement target and by expanding the existing refugee family reunion rules. And the government could collaborate at an international level to build protection capacity in the region of origin and in Europe, and to facilitate more effective life-saving rescue operations in the Channel, in the Mediterranean and at the borders of Europe. And there's no denying that the political environment for refugee rights in the UK and globally is not good. The trajectory is definitely towards greater securitization, towards exclusion, and the abdication of protection obligations. But we don't believe that the 1951 Convention has had its day, and we think it's more relevant and necessary than ever. But we need to be better at making a persuasive argument for the principles, the values, and the vision that informed its drafting. Because if the Rwanda litigation and the treaty and the new bill have shown us anything at all, it's that legal adjudication and democratic processes are essential safeguards, but they must be accompanied by a transformation in public perception of our international human rights obligations if we're going to preserve what's left of the UK's asylum system.
Thank you very much, Sheila, and thank you to all the panellists.